This is Bloomberg Law with June Grasso from Bloomberg Radio.
Obamacare is back at the Supreme Court for the fourth time. The latest case challenges the task force that recommends some of the medical services health insurers must cover free of charge under the Affordable Care Act. For example, cancer screenings, statins to prevent heart disease, and medication to prevent HIV. The ultra-conservative Fifth Circuit Court of Appeals found that the structure of that task force is unconstitutional under the Appointments Clause. The Biden administration appealed to the Supreme Court, saying that decision jeopardizes the availability of critical preventive care for millions of Americans. Joining me is healthcare attorney Harry Nelson of Leech Tishman Nelson Hardiman. Harry, this isn't a threat to the entire law. Tell us what's at stake here.
In this case, which is called Becerra versus Braidwood Management, is a case that's bringing together challenges to the constitutionality of several provisions of the Affordable Care Act. It's a little bit of a grab bag. The only theme that seems to tie all these services is that they are all forms of preventive health care. So there are three main issues. One is that the Affordable Care Act requires insurance companies to cover 50 preventive services, including HIV prevention medications, which have become somewhat controversial in certain quarters, vaccinations, cancer screenings, and it does not require patient cost sharing, meaning patients to pay co-pays and to have to pay any deductibles or any portion of responsibility. That's one provision, is this preventive services mandate. And then there's also an argument being made that the various services, particularly the U.S. Preventive Service Task Force, are unconstitutional. That's more of a procedural issue of how the members of that task force are appointed and the fact that they're not appointed by the president or confirmed by the Senate. And finally, there are a series of religious objections being made, particularly on HIV prevention drugs. There's a therapy called PrEP, which is being funded, and some of the plaintiffs are arguing that it infringes on their religious beliefs to have to be forced to provide this sort of prophylactic treatment that covers the cost of PrEP.
As you mentioned, the plaintiffs here are Christian businesses suing over Obamacare. Now, the Fifth Circuit, it seems like what they upheld is that the structure of the U.S. Preventive Services Task Force is unconstitutional under the Appointments Clause. So this is the argument that we've heard before and that has succeeded sometimes about whether or not they're principal officers or inferior officers.
First of all, the case was brought by, even though it's in the name of a business that was forced to cover people, the case is being funded and initiated by a prominent conservative activist in Texas, Dr. Stephen Hotz. And the argument is about this task force and essentially assigning of power to a panel of 16 volunteer members who are nationally recognized experts in things like preventive medicine, family medicine, pediatrics, epidemiology. They're chosen by a federal agency within the Medicare program called the Agency for Healthcare Research and Quality, AHRQ. So it's kind of a technocratic panel. It's not a political appointment. And part of the argument here is that the decisions they're making are political decisions that really should be appointments by the president and confirmations by the Senate. And the argument seems to be that the task force is really operating without sufficient oversight as a result of the way it was set up in violation of the Appointments Clause of the Constitution.
First of all, this went to Judge Reed O'Connor in Texas, who is the judge notorious for striking down Obamacare in its entirety, and that was overruled. And even the Fifth Circuit narrowed his decision. He had an injunction nationwide.
It was clear that the Fifth Circuit was trying to narrow the decision. Judge O'Connor's decision was a very aggressive, conservative activist opinion, I think is the way most people view it. And while they do take quite seriously the Appointment Clause issue, I think some of the other arguments about religious freedom are issues that were already tried, for example, in the Hobby Lobby case before the Supreme Court more than a few years ago in the early days of the Affordable Care Act. And my sense is that the Fifth Circuit wanted to focus attention on the Appointments Clause argument because that's definitely a very grounded textual argument and a fight that's going on in this country between, liberals and conservatives over the authority to make appointments to organizations like this and the extent to which they have to follow the process set out in the Constitution, or whether, more creative mechanisms can be set out. I don't think when this particular panel was created, anyone envisioned there to be controversy over the particular therapies, whatever with PrEP or anything else. But it is clear that these issues are now political, and so I do think that that issue is going to be an interesting one. Supreme Court is going to have to tangle with.
So the Solicitor General said that if this decision is affirmed, that it could affect things like cancer screenings. I mean, things that have nothing to do with, the religious objections of the plaintiffs.
I do believe that the issue around cancer screenings had a political issue. The cancer screenings were particularly for cervical cancer and also were related to screenings for mammograms. And I think there were a lot of concerns about sort of women's health, and this particular advisory panel, making recommendations that were liberal, and a perception that, that they were supporting sexual activity, for example, when abstinence should be encouraged outside of marriage. There were definitely some other conservative issues beyond the obvious one of PrEP, which has become such an important therapy for HIV prevention. But I do think that's the underlying issue with the inclusion of cancer as one of the areas that they were objecting to.
So the Biden administration is appealing, but the Trump administration is coming in, and it's been consistently hostile to Obamacare. It might not defend the law, right?
Yeah, it's interesting. The Biden administration was clearly opposing and really arguing that this task force operates as an advisory body rather than as an agency that has final authority, so that it was not triggering an appointments clause issue. But I do suspect that the Trump administration is likely to not defend the law, to favor a sort of broad reading of federal power under the appointments clause. And so my sense is that within conservative political activist community, there's a belief that the current court will support that reading. So I do think that both the administration and the court are receptive to that central argument here.
If that happens, this applies so far, this injunction, only to the plaintiffs here. But that could lead to a lawsuit asking for nationwide relief if the court upholds this.
Yeah, absolutely. What's really interesting, and again, if you go back to, I don't have the year in front of me, but I think it was 2014 or 2015, we had the Hobby Lobby decision, which was about conservative religious employers' desire not to be forced, to cover certain costs like birth control. What we're seeing here is a broader set of issues being subjected to religious liberty claims. And so I do think that you could see more employers and a broader range of programs potentially following the lead of the plaintiff in this case. And so, yeah, I do think there is a significant potential impact on access to care and potentially a huge public health backlash. For example, if cancer screenings go down, because insurers or employers aren't required to, waive cost-sharing requirements, I think this could be particularly burdensome for small employers. And it really is kind of awakening religious liberty arguments again.
The Supreme Court has upheld Obamacare 3 times. It's a program that people like and need, and there are constant attacks on it. There have been something like 2,000 different lawsuits.
I think we're looking at a very different Supreme Court right now. If you remember back to the original challenges, we saw a court where John Roberts was the center of the court, and his decision to separate from his conservative colleagues at that time, where it was a 5-4 conservative advantage, swung things. Now, with the 6-3 conservative advantage, John Roberts joining and sort of taking the same position or similar position to the views of the Affordable Care Act he took back when we were dealing with this 10-plus years ago. Now you're looking at Brett Kavanaugh and at Amy Coney Barrett. And so a very different makeup on the court and potentially a willingness to go and take more aggressive positions. So I do think it's going to be interesting to watch this case because it will be telling that even fairly recent Supreme Court precedent may be, up for reevaluation. And I think that's part of the backdrop and context of this case that a lot of people are going to be watching closely.
The PSTF requires insurers to cover more than 50 preventive services. Are those all in jeopardy if the court affirms this decision?
The case is challenging the entire validity of the U.S. PTF, of the Prevention Task Force, and it certainly jeopardizes everything that they were doing, and who knows, that could lead to a backlash. And I also think, even though this case is only about that task force, that kind of feature of use of clinical specialist advisory, support for the government, for government plans, was a central part of the Affordable Care Act in a number of other respects. And I think this is, in some ways, an attack on the participation of the healthcare community, the scientific community, on that process without the president's imprimatur, without the Senate's confirmation. So I do think that this is potentially a much bigger issue, even though the flashpoint that brought it are these particular issues that drew, religious objections from conservative Christians.
Harry, before I let you go, I want to ask a couple of questions about health care in the upcoming Trump administration. The abortion pill, mifepristone, is being used in a majority of abortions these days. Could Trump direct the FDA to revoke the approval of mifepristone?
That's a big question that it's been on my mind since the election, and even before. There certainly is a contingency within the conservative activist community who would like him to step in and to direct FDA leadership to re-examine the current policies around mifepristone, its approval, and all of the guidelines that surround it that were changed to make it much more accessible. I do think that is a very real possibility. The interesting question here is that President Trump himself has said that he wants this chapter of abortion issues closed. It clearly has been a political loser until this cycle for the Republicans. And so it's interesting because this is an issue where the conservative Christian legal community clearly wants to take this on and to use the FDA itself to pull back on access to mifepristone and, by extension, telemedical abortion. And the president himself may not be so enthusiastic. So it's going to be interesting to watch where that goes. But I think it's certainly a big concern on the minds of the reproductive health access community.
There's also a concern about vaccines because of the possibility or probability that Robert F. Kennedy Jr. is going to be the HHS secretary. What do you think is the likelihood that he would change federal vaccine recommendations?
I do think it's going to be a period under his leadership, assuming he's confirmed, of really heightened scrutiny for both current and future vaccines, and it's going to mean that the process will move slower. And I don't think we're going to see vaccines going away, but I think that mandates and government advisory issuances around vaccines are likely to change. And I think it's just a change in the culture of vaccinations that is certainly negative from the view of most of the public health community. And my only prayer is that we don't see some massive outbreak of a disease that has largely gone away, something like measles, because of this. But there's definitely going to be a change in the culture, around vaccines, and a lot more sort of scrutiny and skepticism under a Kennedy FDA.
We'll have to wait and see how he does in those confirmation hearings coming up. Thanks so much, Harry. That's Harry Nelson, a partner at Leech Tishman Nelson Hardiman. U.S. Soccer and Major League Soccer will face off against the now-defunct North American Soccer League in an antitrust trial in Brooklyn Federal Court. The NASL claims that U.S. Soccer and MLS colluded to eliminate it from the upper tiers of U.S. men's professional soccer. And NASL is seeking treble damages of more than $500 million. Joining me is antitrust expert Peter Carstensen, a professor at the University of Wisconsin Law School. The NASL is blaming U.S. Soccer and MLS for driving it out of business. What's the main question in the case?
As best I can tell, the key question is going to be whether the decisions that the Soccer Federation made were relatively disinterested judgments on the merits of whether or not a particular league should be allowed to participate at a particular level, or, alternatively, whether these decisions were made with a goal of excluding a otherwise reasonable competitive alternative from access to the market. And what you're looking at is a regulator, and the question is, how did that regulator make decisions? What went into that decision? And what kind of review might there have been of the decision? So if the decision was the product of some kind of a understanding, agreement with the existing upper-level leagues, that there shouldn't be any more comparable leagues allowed in, then that's going to look like an antitrust violation. It's going to look like using that power over access to exclude competition. That's an agreement in restraint of trade. That's illegal. On the other hand, you need some kind of a decision maker about who gets to play at what level. That's the first thing that is really kind of common ground here, as best I can tell. Somebody has to make these decisions. They need to have criteria, standards for making that decision. If the decision is one on the merits, no, your league does not merit participation at either Division I or Division II level, but only at a Division III level, then that's not a restraint of trade in that it's a legitimate, I'd call it regulatory, decision about the credentials of that particular league. This is a very confusing area of antitrust law because antitrust law doesn't recognize these de facto market regulators as being a special case that needs to be looked at in a distinct kind of way. Some of us have tried to say, hey, understand what you're really dealing with. Here's how it can be made more sensible in terms of coherent standards. Everybody knows what the rules are likely to be. But so far, no court has really articulated that kind of a vision. It's the big issue in the NCAA litigation, really, as well.
U.S. Soccer said it rejected the NSL in 2016 because it didn't meet the minimum standards that it was objectively applying, such as minimum stadium seating capacity of 15,000, number of teams, time zone coverage, and other benchmarks. But the federal judge who greenlighted the lawsuit to go ahead said that U.S. Soccer in 2017 waived 21 standards for second division and favored league USL, but denied 2 waiver requests for NASL. So would that sort of discrimination in treatment demonstrate something?
Yeah, exactly. That seems to me to be central to why the judge allowed this case to go forward. This is a tricky thing because in theory, once there's a factual dispute, it's supposed to be decided by the jury. In antitrust cases, judges are more proactive. They've got to decide that a reasonable jury would find this claim sufficiently plausible that it could reach a verdict of liability that the judge would feel comfortable upholding. So the judge is actually doing some weighing of the evidence, even though the constitutional law says, no, judge, you can't do that. In fact, they do it. And so what he's saying here, as best I can tell, is this doesn't look quite right. This is the kind of thing, at least until there's much more explanation by the Federation of why these cases were treated similarly. And even though it was 2 waivers, those were 2 really important waivers, whereas the 21 waivers were relatively minor bookkeeping matters or whatever. But that's going to be for the jury to decide. But what the judge was saying, this looks sufficiently suspicious that I'm going to let it go to a jury. Now, these have gone to juries with mixed results in some of the other sporting cases, and in some other cases, judges have said, no, I'm going to decide that it's sufficiently unlikely that you can prove your claim. I'm not convinced that a jury should be convinced by this evidence. We've had litigation on tennis, on swimming, soccer, and it's all very similar. That is, there's a gatekeeper, and the question is whether the gatekeeper has behaved in a reasonably legitimate fashion. And that distinction between the 21 waivers on one side and 2 waiver requests rejected on the other, that's the kind of thing a judge looks at and says, oh, hey, that could be a problem.
NASL have to show there was an agreement between U.S. Soccer and Major League Soccer?
Yes. At least my impression is that this is a Section 1 conspiracy case, not a Section 2 monopolization case. It may be a conspiracy to monopolize, but it appears that the centerpiece of the plaintiff's case is that there was an agreement, an understanding of some sort between the established leagues and the regulator, the goal of which was to exclude this potential third rival league. So that requires evidence of some kind of an understanding. Now, antitrust does not require a written contract. It requires that there be some kind of an understanding between the parties. Again, this is where it gets complicated in terms of what does the evidence show, sort of on one extreme. The evidence could show that there was no communications from these 2 leagues to the Federation, but that the leaders of the Federation felt that in terms of the best interests of soccer, they really needed to limit the number of leagues playing in Divisions 1 and 2. So that they acted perhaps anti-competitively, but they did so without any kind of agreement or any overt understanding with the 2 leagues. And then you start going over to communications from these 2 leagues. Hey, we really think this is going to create a problem. You need to keep them from coming in regardless of their merit. Now, that sounds a lot like lobbying to me, but what are their relationships? There's a joint marketing. And so one of the things I would look for is, first of all, there's an economic interest on the part of the Federation potentially to limit competition that could reduce the value of the promotion, the revenues that come in. The more you could show an economic interest in doing what they did and lobbying, the more it begins to look like, yeah, there came to be an understanding that they would do whatever was necessary to exclude. But that's why you have a trial. These things are challenging sometimes to establish what the facts are, what the communications were, what emails were sent to whom, what was their economic interest. And that's going to be, I think, central here. If you move it over from Section 1, which it requires the conspiracy, to Section 2, that is monopolization, you could make a different argument, which is if you could show that the Federation's economic interests were to exclude competition at Divisions 1 and 2. That's not what it is supposed to be doing. It's supposed to be making decisions about who's qualified to play, but because it's got an economic relationship with 1 or 2 leagues, it comes to have an economic interest that causes it to use its monopoly power. And the monopoly power here is in some way unavoidable because somebody has to make these decisions and they're going to control access to professional soccer. But if they're doing it to protect their economic interests rather than in the best interests of the overall program of soccer, that would also create an antitrust problem.
And this trial is expected to take 2 weeks. Coming up, could there be a settlement? This is Bloomberg. I've been talking to antitrust expert Peter Carstensen of the University of Wisconsin Law School about U.S. soccer and Major League Soccer facing off against the now defunct North American Soccer League in an antitrust trial in Brooklyn Federal Court. Peter, U.S. Soccer stripped NASL even of its original Division II status. I understand why they didn't want it to be Division I, but why did they strip it of even Division II?
Indeed, that's a really interesting question because you move them down to 3, as best I can tell. You essentially make them a really low-level farm league, and that's not going to attract audience. It's not going to attract good players. So it's a way of killing the enterprise, which effectively they did, because this is a damage case, not an injunction case at this point.
Speaking of damages, they're asking for treble damages, which you get under antitrust law. Do you know how they're estimating their damages?
I'd say creatively. There's a whole special business of economists who work for plaintiffs figuring out how to estimate the loss. I guess they were for a while Division II. So they've got some kind of a track record. So you take that. You look at what the other leagues had by way of audience and more specifically revenue. And then you create an economic model that predicts what revenues there would have been if they had been allowed either to remain as 2 or been allowed to move up to 1 based on both their own track record and the performance of these other leagues in the United States. They may well have taken performance information from the various leagues in Europe and then compared those to the comparable American experience, and then, again, used this to draw an inference. If these foreign leagues, when they moved from 2 to 1, got a 30% increase in revenue, and we see the kind of distinction in the United States between the Division II and the Division I, we can now, begin to make an estimate. I don't do this, so I am permitted, I think, to be a little cynical. My object as an economist is to come up with the biggest plausible number I can. I worked for years with an economist co-teaching a class on antitrust law and economics, and he did a lot of expert work. He once told me that he tried to be pretty careful about how he did it. So moving away from my cynicism about economists to an economist I worked with and respected greatly, and he'd always try to find, he said, at least 2 and maybe 3 ways to estimate an economic loss. For purposes of damages, he would choose the lowest of the 3 results. He testified all 3. Using this model, I get 3x. Using this model, I get 2x. Using this model, I get x. So the thing I'm surest about is that the loss is at least x. Yeah, you think about it, that's not a bad strategy. Each measure involves an enormous number of assumptions, relationships that you assume. It's very tenuous in that way. I know the judge expressed skepticism about the damage estimates, and that was partly, I think, that he'd really like these guys to settle this, not for $500 million, but, $150, $200 million, somewhere in there. He doesn't really want to have a 2-week trial in an antitrust case.
But this has been going on for about 8 years. Wouldn't they have settled already if they were going to?
No. First of all, the defense lawyer's interest, they're getting paid $1,000 an hour. They've got no incentive to tell their client to settle. And until the judge ruled, as he did only fairly recently, as I understand it, on the summary judgment motion. Up to that, there's 3 steps here. First step is you file a complaint. The defendant makes the motion to dismiss that the complaint does not state a claim. Judge rejects that. Then you go to discovery, your expert reports, etc. If the issue is clear, and I've seen this in a case involving conspiracy among meat packers to fix wages of workers. The judge said, hey, this is a plausible cause of action. Oops, hey, plaintiffs, can we settle this right now? So, no, they knew that they were in deep, deep trouble, and they wanted to settle it. Once the judge said, we're going to go forward. Other cases, the judge is going to say, no, this states a claim. There's some issues here. You do the discovery. And when that's all done, when you've got the expert reports, everything on the table, then comes the motion for summary judgment. The defendant says, this case is not plausible. A jury could not plausibly find in favor of the plaintiff for the following 10,000 reasons. Defendants prevail in an awful lot of those cases, especially in complex cases like this one. The judge says, well, yeah, it's a possibility, but it's not sufficiently plausible given the evidence for me to allow it to go to a jury. So it makes sense, especially in a case like this, which has got a lot of complexity, as we've already talked about, for the parties to hang in and get to the summary judgment motion decision. Now that they've lost that, do they want to go to trial or not?
Well, I believe they're starting with jury selection.
Then they're probably also having some last-minute, fairly serious discussions. And it is quite possible that a number of offers have been made. The plaintiffs want substantially more dollars than the defendants are prepared to put up. And both sides are going to be looking at this in terms of probabilities. How probable is it that the jury would find the violation? And how probable is it that having found a violation, the jury will award something approximating the $500 million? And given the judge's skepticism about the dollar value, this could wind up like the famous American Football League versus National Football League antitrust case, where there was so much other evidence that the American Football League was in serious trouble. One of the key team owners was a guy named Donald Trump, who'd screwed things up terribly. But that's the only team owner whose name I would now recall. So at the end of the day, the jury found that there was unlawful monopolization and or conspiracy to monopolize by the NFL. But almost all the damage was caused by bad business decisions by the American Football League. They nevertheless awarded the magnificent sum of $1, trebled.
That doesn't go very far, does it?
No, but then the other thing that's in that statute is not only treble damages, but a reasonable attorney's fee. And so the lawyer said, well, we won. We didn't get very much, but we want, what sticks in my mind is $20 million. But it could have been $50 million, it could have been only $10 million. But they wanted something in the millions as their reasonable attorney's fee, and they had their hours, all their records. And the judge said, that's what the statute says. You're entitled to your money. Well, they appealed to the Third Circuit, saying, hey, wait a minute, you can't do this to us. It was only $1 trebled damages. And the Third Circuit said, no, the statute says if you violate the antitrust laws, you got to pay a reasonable attorney's fee as well. So my guess, and I don't know how active the judge is, some judges can be very demanding, if you will. That is, saying to the parties, you really should settle this. I was involved in a case many, many years ago where the judge basically said, you're going to go into that room, and you're not to come out until you've got this settled. Judges aren't supposed to do that, but the judge did, and the parties, they settled it. That comment about damages looked to me to be a clear flag. The judge is saying, I think there's a really good antitrust case here. I think the damages are exaggerated. Why don't you guys settle? And egos get involved. It would not surprise me, however, as they start selecting jurors, somebody says, we really may want to settle this for X $100 million, rather than letting a jury make a decision.
The joys of trying a case. Thanks so much for being on the show, Peter. That's Peter Carstensen, a professor at the University of Wisconsin Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.